者可以在頁面上選擇語言的頻道。請注意，我哋今天嘅論壇將以普通話同埋英語進行，並設有英語、普通話同埋粵語嘅同傳服務。如果大家需要耳機，請到入口嘅服務台領取。請注意，頻道1係英語，頻道2為普通話，頻道3為粵語。而線上參加者可以喺網頁嘅畫面上面可以揀選語言嘅頻道，請大家注意。Also on the screen, you will find the QR code to access today's program, Q&A sessions, and feedback form. We hope you can share your feedback with us after the event today. We would greatly appreciate your feedback. 请注意，在屏幕上显有二维码，今天可以查阅今天的议程、提交问题以及填写今天活动的意见表。我们非常期待在活動結束之後收到大家寶貴嘅意見。請注意，大家喺熒幕上面見到有二維碼，可以查閱今日嘅議程、提交問題同埋填寫活動嘅意見表。我哋非常期待喺活動結束之後收到大家寶貴嘅意見。In-person participants who wish to apply for Continuing Professional Development (CPD) credits from Law Society of Hong Kong or Advanced Legal Education (ALE) credits from the Hong Kong Bar Associations should kindly register at the reception desk. Upon departure, please present the QR code once again outside the conference hall to complete your attendance record for today. 请注意，申请香港律师会的持续专业进修学分 CPD， 或者是香港大律师公会的高级法律进修学分 ALE 的嘉宾，需要在接待处完成登记。在离场的同時，在會議廳以外再出示二維碼，以完成今天出席登記的記錄。亦都請大家注意，如果係申請香港律師會嘅持續專業進修學分 CPD， 又或者係香港大律師公會嘅高級法律進修學分 ALE 嘅嘉賓，需要喺接待處嗰度完成登記，亦都喺離場嘅同時喺會議廳外再次可以出示二維碼，以完成今天出席嘅一個記錄登記。唔該咁多位。 Ladies and gentlemen, the third legal forum on interconnectivity and development will start shortly. Everyone, please be seated and switch your mobile phones or electronic devices to silent mode. 各位嘉宾，第三届融通与发展法治論壇即將開始，請各位就座，並把手機或電子設備調到靜音模式。各位嘉賓，第三屆融通與發展法治論壇即將開始，請各位就座並將手機或電子設備調到靜音模式。Please note the event today will be conducted in both English and Putonghua, with simultaneous interpretation in English, Putonghua, and Cantonese. On-site participants may collect headsets at the help desk at the hall entrance. Please note, Channel 1 is for English, Channel 2 is for Putonghua, and Channel 3 is for Cantonese. Online participants, you may select your preferred language channel on the Hong Kong Legal Week website. 今天的论坛将以普通话以及英语进行，并设有英语、普通话以及粤语的同传服务。如果需要耳机，请到入口的服务台领取。请注意，頻道1為英語，頻道2為普通話，頻道3為粵語。線上參與者可以在網頁上面選擇語言嘅頻道。今日我哋嘅論壇將以普通話同埋英語進行，並設有英語、普通話同埋粵語嘅同傳服務。如果需要耳機，請到入口服務台領取。請大家注意，頻道1為英語，頻道2為普通話，頻道3為粵語。而線上嘅參與者可以喺網頁嘅畫面上面選擇語言嘅頻道。On the screen, please note, you will find the QR code to access today's program. You can also access the Q&A sessions as well as the feedback form. We hope you can share your feedback with us after the event. That would be greatly appreciated. 请注意，在荧幕上显示有2维码，可用于参与今天的议程、提交问题以及填写今天的活動意見表。我們非常期待在活動結束之後收到大家寶貴嘅意見。請注意喺熒幕上面而家顯示有2維碼，可以用嚟查閱今日嘅議程、提交問題同埋填寫活動嘅意見表。我哋非常期待喺活動結束之後收到大家寶貴嘅意見。In-person participants who wish to apply for continuing professional development (CPD) credits from the Law Society of Hong Kong or advanced legal education (ALE) credits from the Hong Kong Bar Association should kindly register at the reception desk. Please note, upon departure, please present the QR code again outside the conference hall to complete your attendance record for today. 请注意，今天申请香港律師會的持續專業進修學分 CPT 或者是香港大律師公會的高級法律進修學分 ALE 的嘉賓，需要在接待處完成今天的登記，同時也是在離場的時候，在會議廳外再次出示2維碼，以完成今天出席登記的記錄。請注意，大家申請香港律師會嘅持續專業進修學分 CPD， 又或者係香港大律師公會嘅高級法律進修學分 ALE 嘅嘉賓，需要喺接待處完成登記，同時亦都喺離場嘅時候喺會議廳外再次出示2維碼，以完成今天出席嘅登記。多謝咁多位。Good afternoon and welcome back, everyone. Deputy Commissioner, Mr. Zhang Changwei, the Honorable Mr. Paul Lampton Kwok, distinguished guests, ladies and gentlemen, good day once again. Welcome to the third legal forum on interconnectivity and development, co-organized by the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administrative Region and the Department of Justice. Just to reintroduce myself once again, my name is MC Melody Kwan, and I am your MC for this afternoon. Before we begin our program for today, I would like to invite everyone to join me in observing a moment of silence. Last week, a devastating fire in Tai Po claimed many lives and left many injured. Let us take a moment to remember those who lost their lives, those that are still recovering, those missing, and all the families and individuals affected by this tragedy. In order to maintain a solemn atmosphere to show the respect to them, everyone, please refrain from giving applause or clapping hands during the ceremony today. May I now invite all of you to please stand up and observe 1 minute of silence with me. Thank you, everyone. Please be seated. To kick off today's forum, may I invite Mr. Zhang Changwei, Deputy Commissioner of the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administrative Region, to board the stage to deliver the welcome remarks. Mr. Zhang, please.
The Honorable Deputy Secretary Zhang Guojun, the Honorable President Huang Jin, the Honorable Secretary General Christopher Bernasconi, the Honorable Secretary General Ignacio Tirado, distinguished guests, friends, ladies and gentlemen, good afternoon. Before delivering my remarks, I would like to express, on behalf of the Commissioner Cui Jianchun and the Commissioner's Office, our deepest condolences over the tragic fire incident in Taipu. We extend our sincere sympathies to the families of the victims and those affected by the disaster. We also pay high tribute to the brave firefighters, medical personnel, all other frontliners, and the volunteers for their selfless dedication. This is the third year that our Commissioner's Office and the Department of Justice of the Hong Kong SAR government have co-hosted the Legal Forum on Interconnectivity and Development. This year's forum will explore two key themes: multilateralism and emerging technologies, and discuss how international law can help tackle global challenges and make multilateral mechanisms more effective. We will hear ideas on how to improve governance in key fields like the digital economy, AI, and outer space, all very timely topics. We are very honored to have renowned experts from around the world here with us, ready to share valuable insights. On behalf of our Commissioner's Office, I extend a very warm welcome to all of you. This year marks the 80th anniversary of the United Nations, a pivotal year for global governance. 80 years ago, the Chinese people fought bravely in Asia, making tremendous sacrifices to defeat Japanese militarist aggressors and contributing significantly to the complete victory of the World Anti-Fascist War. Guided by hard-learned lessons from history and the vision of the world free of war and with lasting peace, China joined other nations in establishing the UN, helping multilateralism take root in the international community. 80 years on, our society has entered the digital age, with frontier technologies like AI, big data, and the digital currencies rapidly emerging. The shaping of international rules for these new areas is still unfolding. At the same time, the world has entered a new period of turbulence and transformation. Unilateralism is resurfacing, and the international system centered on the UN and the international order, underpinned by international law, face serious challenges. How to reform and improve global governance has thus become a crucial question that demands the world's attention and reflection. In September this year, President Xi Jinping put forward the Global Governance Initiative at the Shanghai Cooperation Organization Plus, offering China's answer to this question of our times. The initiative states the principles, approaches, and pathways for reforming and improving global governance. It adds stability and certainty to an unstable and uncertain world, and demonstrates China's role as a responsible major country in the world. First, the initiative champions sovereign equality and promotes global governance through broad participation. It upholds that all countries, regardless of their size, strength, or wealth, have the right to choose their own social systems and development paths, and to participate in international affairs on an equal basis. It is definitely unacceptable that certain countries are at the table while others are on the menu. Second, it upholds international rule of law and advances just and orderly global governance. The initiative advocates that international rules should be formulated based on broad consensus, and that international law must be applied uniformly and interpreted in good faith. It opposes imposing one's own house rules upon others, applying international law selectively based on one's own interests, or practicing double standards and exceptionalism. Third, the practices multilateralism and calls for united and cooperative global governance. The initiative asserts that global affairs should be discussed by all, the governance system built by all, and its outcomes shared by all. It rejects unilateral acts such as walking away from treaties and groups, and stopping payments and supplies, and opposes the formation of discriminatory and exclusive groupings. Fourth, it champions a people-centered approach and promotes equitable and inclusive global governance. The initiative holds that the people of all countries are the fundamental participants in and the beneficiary of global governance. We must not erect walls and barriers or pursue decoupling and supply chain disruption to block the modernization efforts of other countries. Still, let's use illegal and unilateral sanctions to undermine their people's legitimate right to development. Fifth, it emphasizes an action-oriented approach and advances practical and efficient global governance. The initiatives calls on developed countries to honor their commitments by providing more resources and public goods. It also encourages developing countries to strengthen cooperation and self-reliance while contributing to the best of their abilities. The international community must replace empty rhetoric with tangible cooperation to ensure that discussions lead to decisions and decisions to actions. Ladies and gentlemen, last month, the fourth plenary session of the 20th Central Committee of the Communist Party of China was successfully concluded. The session adopted the recommendations for formulating the 15th five-year plan, outlining a blueprint for China's economic and social development over the next 5 years. It also made specific and important plans to support Hong Kong's development. As a special administrative region of China, Hong Kong is an important pivot for the country's participation in global governance. Under the new circumstances, I would like to share 3 observations on how Hong Kong can leverage its unique advantages to contribute to global governance. First, leverage the strengths of one country, two systems, and serve as a role model in international cooperation. Under one country, two systems, Hong Kong enjoys distinct international advantages and a broad space for global engagement. Since its return to the motherland, with the support of the central government, Hong Kong has continuously expanded its network of international agreements and deeply participated in the negotiations of multilateral mechanisms like the WTO, playing an increasing prominent role on the global stage. We expect Hong Kong to continue upholding the values of peace, inclusiveness, openness, and shared benefits, and to create more successful examples of win-win cooperation. Second, leverage Hong Kong's unique strengths in the rule of law and serve as a pioneer in dispute resolution. Hong Kong has a robust legal environment that aligns well with international rules, combining the strengths of both common law and the civil law systems. This gives it unique advantages in developing legal services, particularly in dispute resolution. The recent establishment of the International Organization for Mediation's headquarters in Hong Kong fully demonstrates the international community's confidence in its rule of law. We expect Hong Kong to further consolidate its competitiveness, grow its dispute resolution services, and become a global mediation hub. Third, leverage Hong Kong's strengths of a big talent pool and serve as a new force for global actions. As a place where East meets West, and a global financial, shipping, and trade center, Hong Kong enjoys a unique ability to attract a large pool of highly skilled professionals. In recent years, many motivated young people from Hong Kong have already taken up posts within the UN system and other international organizations like the Hague Conference on Private International Law and the UNIDROIT. We hope they will inspire more young people from Hong Kong to go on global stage and contribute their share to better global governance. Ladies and gentlemen, the world today is undergoing changes on a scale not seen in a century. Integration is an unstoppable historical trend. Development a universal pursuit of the international community, and global governance a matter of a common well-being for humanity. We stand ready to work hand in hand with the international community to act on the global governance initiative and build a more just and equitable system of global governance. We are also confident that Hong Kong SAR will seize the new opportunities of our times and achieve new success in supporting the country's participation in global governance. With that, I very much look forward to hearing the insights of our distinguished guests. In closing, I wish the forum a complete success. Thank you.
Thank you. Thank you, Mr. Zhang, for the welcome remarks. Please be seated. Thank you once again. Our program today will feature the keynote speech that is by Professor Huang Jing on the global governance initiatives, and we also will have 2 panel discussions on some of the very important issues on international governance and international law. But before that, everyone, let us invite the co-organizers, the moderators, as well as our speakers on stage for a group photo. Now, I would like to invite Deputy Commissioner Mr. Zhang Changwei. Please board the stage. Thank you. Secretary for Justice, Mr. Paul Lam. Dr. Christophe Berlusconi, please join us. Professor Ignacio Tirado, please. Deputy Secretary for Justice, Mr. Chen Kuo-kwan. Thank you. Professor Huang Jing, please join us. Professor Zhao Yun. Please. Professor Wang Guiguo. Professor Huang Jiefang. Welcome. Professor Wu Xiaodan. Thank you for joining us. Dr. James Ding. Last but not least, Ms. Zhou Qian, please join us. Thank you. Everyone, please direct your attention to our photographers and follow the instructions and take one step back. Perfect. Maybe one more step? Okay, this is good. Just towards me, one baby step towards me. Okay, thank you very much. Everyone, please direct your attention to the cameras. Let's take a few more. Thank you for holding. Wonderful. Thank you very much. Everyone, please be seated. Thank you once again. Please follow the instructions from our lovely staff. Thank you. Appreciate it. Thank you once again. Ladies and gentlemen, it is time for the keynote speech. Please note that the keynote speech will be delivered in Putonghua. For those who require simultaneous interpretation, please kindly collect a headset from our staff around the hall. May we invite Professor Huang Jing, President of the Chinese Society of International Law, to board the stage to deliver the keynote speech titled Global Governance Initiatives in China's Contribution to the International Rule of Law. Professor Huang. Thank you very much. Over to you.
Distinguished guests, Mr. Zhang, and also colleagues and friends, ladies and gentlemen, good afternoon. I'm very happy to join the third Legal Forum on Interconnectivity and Development. The world today is undergoing profound changes unseen in a century, and peace and development faces severe challenges. Global issues such as geopolitical conflicts, climate change, public health crisis, and development gaps are emerging one after another. While the existing global governance system appears inadequate, at this historical crossroads, China, upholding its responsibility as a major power, has proposed the Global Governance Initiative aimed at promoting the building a community with a shared future for mankind. Today, I will discuss three issues on the theme of China's contribution to the Global Governance Initiative for International Rule of Law. First, the significance of the Global Governance Initiative. Second, the symbiotic relationship between global governance and international rule of law. And thirdly, China's contributions to promoting the reform and the construction of the global governance system and practicing the international rule of law. First of all, let's delve into the understanding and the core concept of the Global Governance Initiative. On September the 1st, 2025, President Xi, while chairing the Shanghai Cooperation Organization Plus meeting in Tianjin, declared to the world, "I'm willingly to put forward a global governance initiative and work with all countries to promote the building of a more just and reasonable global governance system and jointly move towards a community with a shared future for mankind." This global governance initiative is a systematic governance solution proposed to address global challenges and solve global governance problems. It was followed by the Global Development Initiative, Global Security Initiative, and the Global Civilization Initiative. This initiative did not arise out of thin air. It is rooted in a clear understanding of the serious imbalance in the current global governance system. For a long time, the discourse power of global governance has been excessively concentrated in a few development countries, and the rulemaking has often served the interests of specific countries, failing to fully reflect the voices of the vast number of developing countries and the profound changes in the world pattern. Moreover, the current international situation is complex and volatile, severely impacting the international system and the multilateralism centered on the United Nations, and leading to a continuously widening global governance deficit. Faced with the question of what's wrong with the world and what should we do, Chinese leaders, with foresight, formally proposed a global governance concept centered on consultation, joint contribution, and shared benefits, elevated to the Global Governance Initiative. This is a powerful response to unilateralism, protectionism, isolationism, and hegemonism, and a Chinese solution for improving the global governance system. The Global Governance Initiative has rich connotation. China's proposal of the Global Governance Initiative aims to focus on the contemporary issue of what kind of a global governance system to build and how to reform and improve global governance in order to uphold the purpose and the principles of the UN Charter and practice the global governance concept of a consultation and co-construction and sharing, and promote a more just and reasonable global governance system, and work together towards a community with a shared future for mankind. Its connotation is very rich and it can be summarized as the 5 adherences. The first adherence is to adhere sovereign equality. This is the primary premise of global governance. Sovereign equality is a fundamental principle of international law. Its essence lies in the fact that the sovereignty and the dignity of all countries, regardless of size, strength, or wealth, must be respected, and their internal affairs must not be interfered. They all have the right to independently choose their social system and development paths, and they all have the right to participate, make decisions, and benefit equally in the global governance process. Secondly, adhering the rule of international law. This is the fundamental guarantee of global governance. International law is the code of conduct for the international community, a crucial instrument of a global governance, and a universally accepted discourse system. The rule of international law refers to the rule of law activities of a global governance based on the principles, rules, and institutions of international laws. The international community must firmly uphold the basic norms of international relations based on the purpose and the principles of the UN Charter. For emerging fields, we must accelerate the formulation of international rules on the basis of broad consensus. We must build an integrated international rule of law system encompassing international legislation, law enforcement, and the compliance and the legal services, ensuring the equal and unified application of international legal rules, avoiding double standards, and refraining from imposing the domestic rules of a few countries on others, and to uphold and enhance the authority and enforceability of international law. Thirdly, adhering multilateralism, and this is the fundamental path to global governance. True multinationalism requires upholding the global governance concept of a consultation, joint construction, and shared benefits. Global affairs should be discussed by all. The governance system should be built by all, and the results of a governance should be shared by all. And the unilateralism is unacceptable. The United Nations is the core platform for practicing multilateralism and advancing our global governance. We must firmly uphold the status and authority of the United Nations and effectively leverage its irreplaceable and important role in global governance. Fourthly, adhering a people-centered approach. This is the value orientation of a global governance. The people of all countries are the fundamental participants and beneficiaries. We must improve the global governance system through reform to better address the common challenges facing human society, promote the common development of all countries, and bring greater sense of gain, security, and happiness to the people of all countries. Fifth, adhering the action-oriented approach. And this is the requirement for the implementation of a global governance. The various agendas of global governance are closely linked and require strengthened overall cooperation, coordination, planning, and holistic advancement, and also a comprehensive approach. We must fully mobilize resources from all parties, strengthen implementation, solve practical problems, and strive for pragmatism and efficiency. And this is the content of the global governance. We also see the significance of a global governance initiative. The importance lies in the pointing the way for the reform and construction of the global governance system. And it transcended the old zero-sum game mentality, advocating for a more equitable, just, and inclusive international order. It's not only proposed by China only, it's also a global public initiative, providing all countries, especially developing countries, with a new platform and opportunities to participate in governance and express their demands. And secondly, I'd like to talk about global governance and international rule of law. Having discussed the global governance initiatives, let's also see the inseparable intrinsic connection between the global governance and the international rule of law. It can be said that global governance is the goal and international rule of law is the fundamental path and the guarantee for achieving this goal. It includes three aspects. And the first one is international law. Rule of law is the cornerstone of global governance. Without rules, there cannot be order. In an international community composed of more than 200 sovereign states, any effective governance cannot be separated from universally recognized principles. From the fundamental principles of sovereign equality and peaceful settlement of disputes established in the UN Charter to the international treaty system and also the international trade law and the marine law. International rule of law provides stable expectations and common behavior norms for interactions among different countries.
It constrains powers and protects the weak, serving as an anchor for maintaining the stability and predictability of international order. Secondly, global governance is the embodiment and the practical arena of international rule of law. The international rule of law is not a castle in the air. Its vitality and authority are manifested and strengthened precisely in the governance practices that address global challenges. When we jointly tackle climate change through the Paris Agreement, handle trade frictions through from WTO rules, and coordinate anti-epidemic cooperation through WHO framework, we are precisely utilizing the tools of international rule of law for global governance. The demand for global governance drives the development of international laws, and the improvement of international laws, in turn, ensure the effectiveness of governance. Thirdly, the Global Governance Initiative is highly aligned with the spirit of international rule of law. The co-governance advocated by the Global Governance Initiative corresponds to democratic participation in the international legislative process. Co-construction requires all countries to jointly uphold the international order based on international laws, and co-sharing embodies the value of fairness and justice pursued by international rule of law. Therefore, promoting the global governance initiative is essentially promoting a more mature, perfect, and just international rule of law. The last part of my presentation, China's contribution, a dedicated practitioner from a concept to action. That is China's remarkable contributions to promoting the reform and construction of the global governance system. As a permanent member of the United Nations Security Council and the largest developing country, China is not only a staunch defender of international rule of law, but also an active builder and a contributor of international law. So ever since the founding of the People's Republic of China, in terms of international rule of law, we have made a lot of contributions. For example, we proposed the concept of three worlds and peaceful coexistence, as well as equality, one country, two systems, peaceful development, as well as the shared destiny of human beings. So in terms of the principles of international laws, in the 1950s, China proposed the 5 principles of a peaceful coexistence. These 5 principles are regarded as the fundamentals of international laws, and in resolving international conflicts, we used the one country, two systems mechanism and successfully resolved a lot of issues left over by the history in Hong Kong and Macau, so on and so forth. So in this new era, we have been a firm defender of international law. We have always adhered to the purposes and the principles of the United Nations Charter and respected the basic norms governing international relations. China has got a lot of have entered into a lot of international treaties, totaled over 12,000 of them, and we have signed over 600 international conventions. And basically, China has enjoyed all the intergovernmental international organizations, and we have been fulfilling our obligations in terms of responding to the climate change. We are active in executing the Paris Protocol and have shown our dedication and action in reducing the carbon emission and realizing dual carbon goals. China has been an active builder of international rule of law. China has actively and deeply participated in the formulation and improvement of international rules in the governance of new frontiers such as outer space, cyberspace, and polar regions. China proactively proposes solutions and promotes the formulation of relevant international rules. In the economic and trade field, China has assigned and promoted the entry into force and implementation of RCEP, applied to join CPTPP and DAPA, injecting legal impetus into the construction of an open world economy. Through the Belt and Road Initiative, we have been working together with our partners to shape a new paradigm of international cooperation that is highly standard, beneficial to people's livelihood, and sustainable. At the same time, China is an advocate and a practitioner of a peaceful settlement of international disputes. We adhere to the principle of resolving differences with other countries through dialogues and consultations. On the issues of the South China Sea, China has been working together with ASEAN countries and actively promote the consultation of the Code of Conduct in the South China Sea, which is a vivid practice of safeguarding the regional peace and stability through rules and consultation. At the same time, Chinese judges and Chinese lawyers are also playing an increasingly important role in judicial arbitration institutions such as the International Court of Justice, the International Tribunal for the Law of the Sea, and the Permanent Court of Attribution, contributing Chinese wisdom to the international justice judicial course. We also advocate and promote the establishment of the International Court of Mediation, an intergovernmental international organization in Hong Kong, which is the world's first intergovernmental international legal organization aimed at resolving international disputes through mediation. And finally, China is also a powerful promoter of the dissemination of international rule of law. We support the UN's capacity building projects in the field of international law by establishing the China UN Peace and Development Fund. Domestically in China, we continue to strengthen the education and research of international law, cultivating a large number of professionals who are familiar with international rules and proficient in international rule of law, and reserve strength for the global rule of law. At the same time, we carry out various forms of exchanges and training for young talents from all over the world, especially from the developing countries, to promote the exchange and the mutual learning of different civilizations. Dear colleagues and dear friends, 20 minutes is a very short period of time, but our agenda concerns an infinite future. The Global Governance Initiative, just like a lighthouse lit in the fog, points out the direction for us to improve the global governance system. And the international rule of law will escort the giant ship carrying our humanity towards a more peaceful, prosperous, and just future. China will, as always, be the gatekeeper and the doer of global governance and international rule of law, and work together with other countries in the world to uphold the global governance concept of extensive consultation, joint contribution, and shared benefits, and jointly write a new chapter of a shared future of mankind. Thank you very much.
And please be seated. We have two panel discussions for today, and the biographies of today's speakers and the moderators are available on the Legal Week website. And the QR code for the Legal Week program can also be found on your table or around this hall. Please note. Not only that, after each panel discussion, there will be a Q&A session. Therefore, if you have any questions for our moderators and speakers, you can scan the QR code that is for Q&A on your table around this hall or on the screens that will be displayed later. You can use this to submit your questions through our online form. Our moderators and our speakers will address your questions at the end of each session. Right now, as we are setting the stage, we will have the first session of the forum. Now, the session is titled Practicing Multilateralism and Upholding the International Rule of Law. This will be moderated by Professor Zhao Yun, Henry Zhang, Professor in International Law and Associate Dean, Mainland Affairs, Faculty of Law at the University of Hong Kong. And as we are preparing for the stage right now, everyone, please be kindly reminded that there will be no applause and no hand clapping for today to remain a solemn atmosphere. And we appreciate everyone's effort. Thank you very much. And coming up, can I please invite Professor Zhao and three speakers on stage? They are Dr. Christophe Berlusconi, Professor Wang Guiguo, and Professor Wang Jiefang. 谢谢. Everyone, please make yourself comfortable on stage. Thank you. Thank you for being with us. Thank you. And before we begin, gentlemen, can I please invite all of you to remain in your seat and take the first photo before we start? And after that, I will pass that to you. Thank you, Professor Zhao. And please direct your attention to our photographers right now. Thank you very much. And over to you, gentlemen.
Good afternoon, ladies and gentlemen. It is a great honor for me to moderate this first session. The theme of our session is practicing multilateralism and upholding the international rule of law. In an era of increasing global fragmentation and complex challenges, from climate change to digitalization and beyond, a robust and collaborative framework is not an ideal, but a necessity. It is a very bedrock on which sustainable development, peaceful coexistence, and equitable interconnectivity are built. Today, we are immensely privileged to have three world-leading experts with us to explore the theme from three distinct yet interconnected vantage points. They will guide us from the foundational principle of private international law cooperation to the dynamic laboratory of regional integration, GBA, and finally to the final frontier of human activity. For this session, each speaker will have around 15 minutes for presentation to be followed by Q&A. Without further ado, let me introduce our first speaker, Dr. Christophe Berlusconi, Secretary General of the Hague Conference on Private International Law, or the HCCH. For a century, the HCCH has been a powerful engine for multilateralism, creating international treaties that bridge legal divides in cross-border family, civil, and commercial matters. In a world of borders, the HCCH builds bridge. So now I give the floor to Dr. Berlusconi. You have the floor.
Deputy Commissioner Zhang, distinguished colleagues, ladies and gentlemen, at the outset, can I thank the Commissioner's Office and the Department of Justice for the kind invitation to be part of this third legal forum on interconnectivity and development. And also, before I begin, I wish to express our deepest sympathy to all those affected by the terrible fire in Taipo. Our thoughts and prayers are with the victims and their families and communities. Today, I will speak on the evolution of private international law addressing global challenges from the perspective of the organization I have the honor to represent, the Hague Conference on Private International Law, or indeed the HCCH, as we like to call it these days. Our work, our mandate, the development of unified rules of private international law, and indeed our daily reality are deeply intertwined with the evolution and practice of multilateralism and with respect for the rule of law. This close connection between our work, multilateralism, and the rule of law is not an abstract principle. It is the practical foundation that enables cross-border life to function predictably and fairly. From that perspective, there is a simple statement I often use to describe what we do. A statement that, to me, captures a fundamental truth about today's interconnected world. And that is that we live in a world of private international law. Whether we notice it or not, private international law shapes countless aspects of modern life. When businesses sign contracts with partners on other continents, when consumers buy goods online from abroad, when courts determine which law governs a dispute spanning jurisdictions, or when a parent wrongfully removes a child across borders, private international law is already at work. It is part of the invisible infrastructure that makes our interconnected world possible. And because our societies evolve, private international law must evolve too. It has never been static. It has always adapted to the needs of time. If we look back, classical questions of private international law concerned status, family relations, contractual obligations, and civil procedure. Later, growing mobility and international commerce added complexity. Today, digitalization, dematerialized transactions, and new economic models have transformed how people, businesses, and institutions interact across borders. The history of the HCCH reflects this evolution. For more than 130 years, we have developed global solutions to contemporary challenges grounded in proven techniques of private international law. I often use the metaphor of a tree when referring to the HCCH. Deeply rooted, stable, yet constantly growing new branches. Key decisions, such as adopting consensus-based decision-making in the year 2000 and strengthening governance foundations, have reinforced these roots, enabling the HCCH to flourish and embrace its role in this world of private international law. Today, 159 states and parties are connected to our work. Since becoming a permanent organization over 70 years ago, the HCCH has recorded 1,041 treaty actions, that's ratifications and accessions to our conventions, from every region of the world. This is remarkable and a clear reflection of the effective living multilateralism we produce. To establish the same network of treaty relations between states through bilateral agreements instead of the multilateral approach we take, more than 33,600 bilateral agreements would be required, which again emphasizes the effective practical multilateralism that the HCCH stands for. The past 15 years have seen remarkable acceleration. Membership has grown by over 30%, and treaty actions by more than 50%. Yet much more remains to be done, particularly in Africa, where potential is immense, but also in parts of Asia Pacific. The trend, however, is clear. States recognize the relevance of private international law and that coherent global solutions are indispensable for legal certainty, economic competitiveness, and the protection of individuals. But as I said, private international law and therefore the work of the HCCH and its convention need to be adaptable. And that work is adaptable. In the area of family law, for example, take the Child Abduction Convention, which was developed under the premise that back then most abductions took place by fathers, not returning the child after a holiday period. Nowadays, about 80% of the abductions are done by mothers, often in the context of domestic violence. That has had a significant impact on how to operate the convention and called for an inclusive dialogue with all those involved to revisit the operation. And at my initiative, we have had two global fora to discuss precisely this operation. The Child Support Convention of 2007 replaces not less than 4 existing HCCH conventions and a UN convention precisely to provide to the world a modern convention that also takes into account the fact that child support is handled administratively these days in a number of jurisdictions, and it was also designed to embrace the use of modern technology. In other fields like transnational litigation and the authentication of documents, the apostille service and evidence conventions, which will form part of a panel tomorrow, have all been able to adapt to the new reality of new technologies. And alongside these established areas, new domains are emerging, driven by digitalization, new forms of value, and the urgency of climate action. The HCCH is undertaking 3 strategic projects in the field of central bank digital currencies, digital tokens, and carbon markets. CBDCs issued by central banks promise financial inclusion, efficient payments, resilience in crisis, and greater competition in the payments landscape. Although still in development and testing, their future cross-border use is inevitable. That reality will bring significant questions of private international law to the forefront, in particular those related to jurisdiction and applicable law, as well as the interaction between technical design choices and their public law character. An HCCH experts group is already working through these issues with our members, as well as key actors such as the Bank for International Settlements, the International Monetary Fund, the European Central Bank, and many others. The group is drawing up an explanatory guide which will describe the private international law issues that arise in cross-border holdings and transfers of CBDCs. Digital tokens allow tangible and intangible assets, rights, and claims to be digitally represented and transferred. Their use relies on distributed ledger systems that are often non-localized, decentralized, and pseudonymous. These features sit uneasily with certain traditional private international techniques, which depend on identifying a territorial connection. This tension goes to the heart of how legal certainty is maintained in a borderless digital environment, and it's precisely why the HCCH's work on this topic is both timely and indispensable. The experts group on digital tokens is discussing private international law rules for digital tokens such as stablecoins and Bitcoin. UNIDROIT, having previously developed soft law principles addressing digital assets and private law, brings that background into its participation in the group. Moreover, the group has agreed to start drafting a private international law framework for electronic transferable records, fully aligned with UNCITRAL's existing model law on electronic transferable records, MELITA, that was part of discussions yesterday. This is a groundbreaking and indeed very effective and efficient manner of cooperation. The carbon markets project is equally urgent. Discussions at COP30 in Belém, in which the HCCH actively participated, highlighted the central role of private international law in scaling carbon markets responsibility, transparently and fairly. The experts group has been mandated to analyze the full spectrum of private international law issues arising across these markets, from upstream through mid and downstream sectors. Initial attention is given to applicable law considerations that must be clarified if carbon markets are to function with predictability and integrity at the global level. The implications for climate implementation are significant. These projects differ in context but share a common challenge: technologies that unsettle assumptions on which private international law has long relied. Yet the core questions remain: jurisdiction, applicable law, recognition and enforcement, as well as cooperation. Our work is essential to ensure these questions are answered in ways that support innovation, resilience, and the global public interest. These initiatives show that private international law must, can, and does adapt to new realities. Yet as we innovate, we cannot ignore the broader context. The international legal order itself is under strain. Multilateralism and respect for the rule of law are under pressure. Fragmentation looms as national or regional approaches proliferate. In such times, organizations that deliver effective, practical multilateralism that makes a tangible difference to individuals, families, and businesses are more vital than ever. This, in fact, is the HCCH model. All member participates on an equal footing. Sovereignty is respected. Decisions are taken by consensus, and the operation of our instruments is being monitored so that they remain living tools. This approach resonates with principles underlying the Global Governance Initiative, as we've just heard from Professor Wang, which also emphasizes inclusiveness, cooperation, equal sovereignty, shared responsibility, and the need for monitoring of implementation. In a world marked by uncertainty, such principled multilateralism is indispensable. Since we truly live in a world of private international law, the work of the HCCH has never been more important. As the only global organization mandated to unify private international law, we carry both profound responsibility and extraordinary opportunity to provide the legal infrastructure that supports cross-border life, business, and justice, to uphold a predictable and coherent global legal ecosystem, and ultimately to strengthen the international rule of law. Practicing multilateralism and upholding the rule of law through the development of effective, practical, and consensus-based rules of private international law. This is and will remain the core of the HCCH's mission for decades to come. We will continue to link laws and bridge worlds. Thank you.
Thank you, Dr. Bernasconi, for the illuminating presentation. You have shown us that the intricate work of the HCCH, how to harmonize private international law. Actually, this is a cornerstone of a stable and predictable international system. It is a multilateralism working on the ground for people and businesses alike. This concept of building regional legal coherence brings us perfectly to our next speaker, Professor Wang Guiguo. Professor Wang is a towering figure in international economic law and leading legal scholar from Zhejiang University. Professor Wang will shift our focus from global to the regional, with a specific lens on the GBA, which represents one of the most ambitious regional integration projects in the world, bringing together three distinct legal jurisdictions under the one country, two system framework. Professor Wang, you have the floor.
Thank you very much. Honorable Commissioner Zhang Shengwei, President Huang Jin, ladies and gentlemen, we are in a moment of sorrow. We express our deepest condolences to those loved ones we lost. At the same time, I must say that this is a moment of love of this society. Over the last few days, I received a number of messages from several countries. They expressed their love to the people in Hong Kong, their concern not only to those who are directly affected, but also to Hong Kong as a whole. What does this show? It shows interconnectivity. According to Chinese traditional culture, the very source of I Ching, or book of changes, it says that the deepest misfortune will bring good luck. Meaning, In Chinese, we say 否极泰来, meaning that when you are in deep misfortune, we should also see the positive part, to see the light, to feel the love of the people. Why? Also according to I Ching, because this 否极泰来 resembles two holograms. One is smoothness, happiness. The other is difficulties, misfortune. In Chinese, is 泰卦 and 否卦. In the very first line of the sixth line holograms, it says the grasses, when you pull the grasses from the land, you will see that the roots of the grasses are interconnected. They cannot be separated. You pull one grass out, others would be affected. And this is exactly the world today. We are all grasses. We are different type of grasses. We are not the same. That resembles the diversity of the world. The interconnection of the roots of the grasses shows that this world is deeply connected. Also, our feelings are resonant. When one part of the world says something happens in that part of the world, other parts will feel it. When someone is happy, that happiness is shared. When someone suffers, the suffering is shared also by other people. And this is globalization. In this globalized world, what do we need? Of course, we are interconnected. We need some rules to guide our activities. And that is the rule of law. Rule of law is considered, at least to the present, the most efficient means of governance. But what is the rule of law? What is the root of the rule of law? Rule of law cannot be a rule of law without law, of course. Law is the most important. But what is the basis of law? In my view, no law can be separated from the culture, the customs of its own society. The law must reflect the values of the society where it is rooted. And that also means, since we are different grasses, we have diversity of groups of grasses. The rule of law cannot be the same. And therefore, for the governance of this world, we need international rule of law. International rule of law cannot be established, cannot be effective unless it is based on national laws. Well, the national laws are reflected, are based on the cultures and the customs of their societies. International rule of law must also reflect the values of the humankind. Do we have a shared value? We, of course, are from different cultural background, have different customs. Yet, we do have shared values. Because very often when you walk in the street, when you see something nice, something beautiful, you know, you like it, you appreciate it, others will also like it, appreciate it. It doesn't matter where that person is from, whether that person is with a different religion or not. That means we do have shared values. Then how do we maintain the international rule of law? Make sure that international rule of law will work properly, will be very efficient for the international community, for the betterment of the humankind. We have to make it keeping the pace with the time. At the same time, we should maintain the fundamental principles, and that is shared value. In my view, that shared value is reflected in the Charter of the United Nations, based on which the international law order has been established. And the essence of the Charter should be maintained. At the same time, we have to make sure that the Charter will be interpreted, will be enforced in accordance with the changing environment. That is also in accordance with the Chinese traditional culture. While making such changes, it doesn't mean we should forget about our directions. Our direction is very, very clear. That is, we should make this world a better one. We should make international rule of law work for everybody, not just for one type of grass, one piece of land of the grass for everybody. How to make it work? We are in Hong Kong. What is so special for Hong Kong? Hong Kong is the interconnected with the East and the West. We see this room. We have a diversity of people here. Not people from one country, not even people from one race. And this shows our interconnectivity. And that is so special for Hong Kong. As far as law is concerned, Hong Kong's common law system has been adopted by many countries in the world. Common law principles, common law techniques, common law skills have been used, have been adopted by the tribunals in international investment, by International Court of Justice, by the WTO appellate body and panels, as well as by many arbitration tribunals in charge of commercial arbitration. What that shows Hong Kong can contribute to that part of the international legal order? How about the rest of China, including Greater Bay Area? Of course, Greater Bay Area did not mean, except Hong Kong and Macau, did not have the experience of colonization. And that means that part of culture is deeply, deeply rooted in the traditional Chinese culture and custom. Then how can the two parts work together? Here I would like to quote a famous philosopher, Asian philosopher, Zhu Xi. He wrote a poem. In Chinese, he said, I asked the pond, how can the water be so clear? It is because fresh water flows in from its source. 问渠哪来清如许，唯有源头活水来. That's in Chinese. I think joined together by the people in the greater area in Hong Kong, cross the border in mainland China, in Macau, I think we Chinese can serve bringing, providing a fresh water for the international community, to serve the water to the humankind for their betterness. Thank you very much.
Thank you, Professor Wang, for your profound and insightful analysis. It's quite clear that a culture and shared value have very close relationship. The interaction between the two plays a very important role when it comes to the definition of international rule of law. So we can also find out that the GBA is not only an economic engine, but actually very important for legal innovation, as Professor Wang has rightly pointed out. Speaking of global challenges in new frontiers, our final presentation will take us beyond our planet. Professor Huang Jiefang is Secretary General of the Asian Academy of International Law, and also he is a Zhou Gengshen Professor in Wuhan University. The AAIL, Asian Academy of International Law, has been at the forefront of promoting the study and practice of international law in Asia and beyond. Professor Huang will now take us to perhaps the ultimate test of multilateralism and the rule of law, the governance of outer space. Professor Huang, you have the floor, please.
Thank you, Professor Zhao Yun. In fact, you should be the one who addressed the outer space issue, because everybody knows that you are the authorities in Hong Kong SAR for this topic. Nevertheless, since I'm put on the floor, I'll do my best. First of all, 先感谢这个特
And first of all, I'd like to extend my sincere thanks to the Commissioner, Mr. Zhang, as well as Mr. Huang and Professor Zhao. And secondly, I would also like to convey my sincere mourning to the Hong Kong people suffered from the fire disasters.
And challenge. We're talking about interconnectivity. Professor Wang used a very good metaphor that we are different grass. The roots would be together. This grass is not just growing on the earth now. is going to outer space or the universe. Humankind is going to fly outside the earth. This is already irresistible movement. Facing this new frontier in as early as 1967, United Nations has promulgated an important treaty called Outer Space Treaty to regulate the conduct, to reflect, as Professor Wang said, the shared value of the humankind. So what is the shared value? We have 5 agreements, which I do not want to go into it now, but I just would like to point out the most important, in fact, first and foremost principle of Outer Space Treaty. It says the exploration and use of outer space, including the moon and other celestial bodies, shall be carried out for the benefit and in the interest of all countries. I put in the yellow color here. Irrespective of the degree of economic or scientific development, and shall be the province of all mankind. This is the first operative part of the important UN multilateral treaty. Of course, there are other space law principles, such as the principle of non-appropriation. Outer space is not subject to claim of sovereignty or any other means. There is also freedom of outer space is open to every state. However, I have to say, as the space activities grow, people tend to remember they have the freedom of in outer space, but they forget the exercise of the such freedom shall be for the benefits and in the interests of all countries. Let's go back to the historical background. At the beginning, some states say this so-called for the common interest of for the benefit of all countries should be put in the preamble. After discussion, this delegation realized it is very convincing to put in the operative part of the treaty as a binding provisions. During the ratification phase, there was a discussion in one of the big space powers concerning this particular clause. The statement say like this: if it is in the preamble, that is one thing, but it is not. It is a provision, a treaty obligation. It requires that the use of outer space be for the benefit and in the interest of all countries. So I'm telling our story now. Why? Because in Chinese we say, 忘记过去就意味着背叛. Forgetting the past means betrayal. Now look at the situation. There was a negative approach to this common interest principle reflected in Article 1, Paragraph 1. First is denial. There's no such thing as a common interest of mankind. States are competing with each other to grab the sphere of influence in outer space. So it's denial. After we argue, no, this is the operative part of the treaty. And when everybody ratifies the Outer Space Treaty, they knew it. Then they start to use devaluation. Okay, it's there, but it is only a political statement. There's no binding legal force. Even worse now, there's even deterioration. Try to ignore it. A typical approach is to assimilate outer space to the regime of the high sea. There's even a typical statement that expresses this kind of idea. It says, while the fish in the high sea, when it is in the sea, it is ours, it is community property. When I catch it in my boat, it's mine. It looks like reasonable. But please do not forget, it implies that if you do not have the boat, you will never get the fish. So who will have the boat? This reminiscent of the previous saying that the truth only exists within the range of canoes, and dignity only lies at the tip of the sword. 真理在大炮射程之内. It basically recognizes those who are strong, rich, powerful, and big may control the state of the affairs. And those who are small, weak, and less powerful, almost like what our Terpaians say, probably not sitting at the table, but become the menu on the table. If you see the international situation today, what I'm afraid that's exactly the situation. Those who have the power seems to have more say. But how should we change it? Well, we should have the counter approach rather than deny, devaluation, deterioration. We should defend, define, and develop the common interest of humankind. And I have to emphasize my thinking in this forum that in the context of Outer Space Treaty, even it was adopted in 1967, but the spirit coincides with the concept of the 人类命运共同体, the community of mankind for the shared future. It emphasizes the common interests, the international community as a whole. And in fact, it's not just the global community now, it's the entire universe. So what we should do to do that? We should do through the cooperation. We already mentioned that we should work together and share the benefits, especially for the smaller states. Probably the only way that you could reap, say, space benefit is through the cooperation. Some people said, you can still have the benefit from the space exploration. We have a good products and we can sell it to you. Well, that is not really sharing of the benefit. That's the nature of commerce. That's not sharing the benefit. You produce the product, you want the whole world to buy your products. You want the market. The real share benefit is really through the cooperation, through the capacity building. I think that's the practical way for many less developed countries. What could Hong Kong do? Hong Kong, as a one unit, as a special administrative region of China, many speakers have already mentioned the advantages of one country, two system. I would like to further elaborate under the leadership of the central government, using its inherent advantages and resources. Hong Kong SAR may promote international cooperation through different ways. One consensus is we are financial center. We are in the position to collect a lot of financial resources. Outer space is a great venture. It's a technology and a capital-intensive ventures. Hong Kong has these advantages. So we have financial center here. Secondly, Hong Kong is very mature in the insurance market. It can provide the insurance to the highly dangerous and highly adventurous space venture. Thirdly, it's more related to our work today here in this room. We can provide legal services. Of course, I will not forget the real efforts to improve the final say in the space legislation. We should strengthen the avant-garde areas of space science and technology. Hong Kong doesn't have so many universities, but 4 or 5 of our universities are listed quite high in the entire world. And many experts develop the technology which have been used either in Shenzhou or Chang'e missions by the mainland China. So this is how Hong Kong can help developing countries through central government to improve the space capacity building. I think that's where we should develop into future sort of Hong Kong. Thank you.
Thank you, Professor Huang. So you have given us a very forward-looking presentation. We have noticed that the process of space commercialization and privatization is ongoing, and a lot of challenges are coming up. Now, obviously, multilateralism remains to be a very important tool for us to come up with a legal regime to realize the international rule of law. Unfortunately, given the time constraints, we will not have the Q&A session. So, ladies and gentlemen, I think through the 3 excellent presentations, we have realized that international rule of law is not an abstract concept. We can find out that international rule of law can be realized through the HCCH's approach of lawmaking, concluding international treaties, through the test in the regional integration like the GBA, but also we can find out that it will need to be defended in the new frontier, outer space. Furthermore, we can find out that actually it's rather important. Multilateralism is an important concept that we have to refer to. It is challenging, we must admit, but it remains to be a very effective tool to realize the international rule of law. So with this, we conclude this session. Thank you very much. Thank you.
Thank you very much for all the sharing, and thank you, Professor, for being our moderator, and thank you to all of our panelists. Everyone, please be seated. Thank you once again. Thank you. Ladies and gentlemen, we will now take a 10-minute break. Refreshments are available outside the hall, and please do take your valuables with you when you leave. And for online participants, please stay logged in as we will reconvene in 10 minutes. Thank you very much.
To our moderator and our panelists on stage, can I please invite you to take a look at the cameras in front of you and take a photo first while getting comfortable in your respective seats. Everyone, please take a photo first. Thank you. Thank you very much. Distinguished guests, ladies and gentlemen, welcome back. Now, welcome back to the third Legal Forum on Interconnectivity and Development. As we resume our program for today, may I gently remind everyone not to give applause and not to clap during the session so we can maintain a solemn atmosphere to show the respect to those affected to the fire in Taipo last week. Our next session is on the promotion and development of international law through emerging technologies, which will be moderated by Mr. Roden Tong. He's the president of the Law Society of Hong Kong. In joining Mr. Tong on stage are our three panelists. We have Professor Ignacio Torrado, Professor Lin Chen, and Professor Wu Xiaodan. There will also always be a Q&A session at the end of the panel discussion where you can scan the QR code on your table around this hall or on the screens. And this is the way that you can submit your questions. So without further ado, I will pass the time to Mr. Tong for the second session. Over to you.
Good afternoon, distinguished guests, ladies and gentlemen. It is my pleasure to be the moderator of this session. So in these sessions, we will examine how to promote and develop international law and legal practice through emerging technologies. Our expert panel will provide latest updates and practical insights on the development of international law in various emerging industries, including digital economy, stablecoins, and artificial intelligence. We are very honored to have with us today a distinguished panel of experts who can provide valuable insights on addressing the latest development opportunities and also challenges in these growing areas. So without further delay, I would like to introduce our first speaker, Professor Ignacio Torrado, Secretary General, International Institute for the Unification of Private Law, UNITRO. Professor Torrado is a leading expert in commercial, corporate, and insolvency law. He was first appointed Secretary General by the UNITRO Governing Council in August 2018 and has been reappointed for a second term. Professor Torrado is a professor at Universidad Autónoma of Madrid. He holds a PhD from both the Universities of Bologne and Automobile de Madrid, as well as an LLM from the University of London. His professional experience includes over 10 years as a senior legal consultant at the World Bank's Legal Vice Presidency and Financial Sector Practice. He has also provided consultation service to the International Monetary Fund on insolvency matters and to the Asian Development Bank on commercial legal reform. Professor Torrado is also a founding member of the European Banking Institute, an international fellow of the American College of Bankruptcy, and has been director and academic co-chair of the International Insolvency Institute. So let us welcome Professor Torrado to share his thoughts on trends in international rule making for the digital economy. Professor.
Good afternoon, Deputy Commissioner Chang, Professor Huang, dear friend, ladies and gentlemen. First, a word of gratitude to the Office of the Commissioner of the Ministry of Foreign Affairs in Hong Kong, as well as to the Department of Justice of Hong Kong for the invitation, and a word of sincere and heartfelt sympathy for Hong Kong and its people on behalf of UNIDROIT for the terrible events this past week. It is quite difficult to start a dialogue after the extraordinary panel that we had the opportunity to hear and speech before. The previous panel was about big ideas and big concepts, and at least I am here to talk about very specific technical things. which is not nice, but I hope it will be useful. It will be, at least, I'll try to make it as little boring as I can. The idea is to talk about trends in international rulemaking, but this is understood as part of the a panel which will look at developments of international trade in the context of new technologies. So the idea here is, what I will talk about very briefly is not a general presentation, but rather specific cases. Why? Because we are convinced that technology as an evolving reality is a game changer. But we do not think that technology has created anything completely new. It has generated a mutation in reality which requires intellectual and professional analysis and thinking. But we do that with the instruments that we have. And we don't start from scratch. We start from legal frameworks which worked with elements and items and assets in the past that are at least analogous in some areas to what has been created now. And that explains why UNITRA thinks that the way to approach technology is, instead of coming up with a completely new system, it's rather to look at it with a view to help clarify the law and to help add legal certainty. If we clarify some concepts as to how things that already existed could be applicable, and if we adopt a position which helps legal certainty, we believe we'll be rendering a service to international trade. I will, of course, limit myself to material law. That's why the concept is such. So case one is going to be about digital assets and its trading. Case two about verified carbon credits, and then we'll see, I will just simply list other items where technology is transforming international trade. First of all, as to digital assets, UNITRA produced its principles on digital assets and private law, which were drafted over a number of years with experts from all over the world and leading institutions, trying to set a standard in an area where there was no standard yet, where there was no identifiable best practice because it was too new. So the process of drafting it was quite complicated. That led our working group, and ultimately our governing council, to adopt a humble approach. That is, instead of trying to regulate everything for private law, we only do private law, that concerns digital assets, the idea was instead to focus on those elements that would need clarification and special rules in the light of the technology that had been developed. So not full replacement, but let's cover the holes of those areas where there is a need for additional input and international and transnational guidance. Because of that, the principles focus on proprietary matters of digital assets. They are technology neutral, and they are designed to work perfectly both in civil law and in common law systems. That is the main purpose of it. How did we approach this? And the main idea I wanted to convey to you today is that the main purpose was really to add legal certainty so that digital assets could be traded internationally with a secure environment, so that there would be an increased willingness to invest because of the contained risk. In order to do that, first of all, we needed, because it was a transactional component that in which we focused, we wanted to provide a definition of digital asset which is quite broad. Please bear in mind that we didn't try to define digital assets in general. We only tried to define digital assets for the purpose of the instrument. And for that purpose, digital asset is described as an electronic record which can be subject to control. Control is the concept that we need to look at. The result of the discussion was quite clearly that it is possible to ascertain, to establish proprietary rights over digital assets, even though it's particular nature. That from that moment on, a number of legal consequences naturally ensued, such as, for example, the fact that security rights could be created over digital assets, securitization of digital assets as well, and that those proprietary rights were in a position to survive insolvency. What was the main, perhaps the main addition to the community of thought in this matter? Was the fact that digital assets as electronic records, which are mostly on a blockchain, have a reality which is obviously intangible. You cannot touch a digital asset. However, the way it works, because digital assets, when they are transferred, they are recreated in a new part of the blockchain. They are not, you cannot transfer a digital asset the way you transfer a tangible property. However, the way it works lends itself to a very interesting analogy, which is you can, if you use the concept of control as the functional equivalent to possession, recreate a system of private law rules which allow you to explain proprietary rights over those digital assets. So control is the basic concept. Control is defined in a way which will be very familiar to both civil law and common law experts, because it refers to the classic elements and composition of a possession. What you have, when you control a digital asset, you can extract most or all the benefit from it. You can prevent others from accessing all or most of it, and you can transfer it. And thus it is the definition of control, which is not a matter of law, it's a matter of fact. Once you have that concept of control, which is almost physical, you can easily derive a number of rules which will add legal certainty to the market. Based on control, for example, our principles have created a principle of innocent acquirer. Innocent acquirer, which is directly linked with the concept of innocent acquisition that each country will have. Second, even more importantly perhaps, it creates a concept of what's called the shelter rule. So if an initial holder of the digital asset transfers by the control of the digital asset to another party, and that person meets the requirements of good faith that a country demands, that person acquires the digital asset. If that person transfers it to a third party, and that third party knew that the initial couldn't transfer it, still protected. This is the shelter rule. So what this does is ensure that these markets, which are quick, international, and difficult to control, enjoy a level of protection in transactions which facilitates its trading. Naturally, we are a private law-making organization. Anything which concerns the protection of the users of the system is regulatory and should be in the hands of the countries to do, and is for other organizations to define. So based on those rules, we created a system. We also detained ourselves in the idea of regulating custodians. It's quite interesting because blockchain and digital assets were mostly created in a peer-to-peer way to avoid intermediaries. And the truth has revealed that intermediaries are essential in this area of the law as well. So we define custody. We provide a number of rules that underscore and underpin legal certainty so that custodians can be adequately regulated in their activity in a way which is compatible with market practice. We even provide specific rules to minimize damage in the case of insolvency of the custodian. Perhaps the most interesting point, and I will not have the time to explain, is that in light of the reality of digital assets, we provide an exception to the classic priority rules that are defined when it comes to secure transactions. So that if you acquire a security interest based on control, that trumps a security interest created by way of registration. And there is a reason for that, which is explained by the very same nature of digital assets, but we don't have the time for that, apologies. So the other, I see the time is coming down, the other project, the other case study, which I wanted to mention, is a very interesting one. A few years ago, an officer from the International Swaps and Derivatives Association said, there is an increasing amount of derivatives being created over this thing called voluntary carbon credits. No one really knows what they are. So it's being traded, but what is being traded? So UNISRA started work with other partner organizations, mostly initially with the World Bank, and still with the World Bank, doing work on the legal nature of verified carbon credits, voluntary carbon credits, but for the part that we analyze, verified, the nature is shared, with the purpose of shedding some light as to what this strange creature of voluntary credits are. Obviously the purpose of this analysis was and still is, because we are in the final stages of it, to clarify things so that markets know what they're trading in, and therefore markets are bolstered, legal certainty is enhanced, and carbon credits grow, because ultimately voluntary carbon credits assist the climate goals as established by the United Nations. So that is the idea of what we did, and no surprise to you, the conclusion that we reached is that it is possible to establish security rights and generally proprietary rights over voluntary carbon credits for a number of reasons. And we devoted a whole year to analyzing these from a theoretical perspective. VCCs can be individuated in a registry, they can be controlled, they are rivalrous in the sense that if one person is enjoying the control over it, another person cannot. Therefore, these three elements of traditional theory of property are applicable to voluntary carbon credits. Therefore, that allows for its use for their transactional use and their use as collateral and their adequate remitted insolvency. And because I have a few seconds, I'll say that there are three other projects in which we are contributing to the promotion of international trade through technology. One of them is our work on receivables financing and the transfer of receivables. We do that now. We have a regulation based on the trading through platforms, technology. The same together with the United Nations Commission on International Trade Law for warehouse receipts, which is key to food security and to the development of agricultural activities. And finally, a new project which we are about to start at the request and in conjunction with the World Bank on investment-based crowdfunding, which is obviously a very important technological tool. Okay, so I rushed. I apologize for the very technical content, and I thank you for your attention.
Thank you, Professor, for your very valuable insights. I think it's very important that to learn about the safety and certainty on the law. So next, it is also my privilege to invite Professor Lin Chen, Vice President and Vice Chancellor of the University of Hong Kong. Professor Lin is the Stiers Professor in Finance and Chair Professor of Finance at the University of Hong Kong, where he also serves as interim vice president and pro-vice chancellor. He has held several key leadership roles at Hong Kong University, including associate vice president, faculty affairs, and associate dean, research and knowledge exchange at the Hong Kong U Business School. Professor Lin directs the Center for the Financial Innovation and Development and is executive director of the Hong Kong U Standard Charter Foundation FinTech Academy. Before joining Hong Kong U, Professor Lin was the Charming Lee Professor in Finance at the Chinese University of Hong Kong and has held distinguished visiting and honorary professorship at institutions such as the University of California, Berkeley, and the University of Edinburgh. He holds a PhD, MA, and MBA from the University of Florida and a Bachelor of Engineering from the South China University of Technology. Professor Lin's research covers banking and financial institutions, corporate finance, financial technology, entrepreneurship, and economic development. He is widely published in top international journals and has received numerous awards, including the Jackson Prize for Best Papers in the Journal of Financial Economics. He has led major research projects funded by national and international agencies. Beyond academics, Professor Lin actively contributes to public policy and serves on advisory groups for the Hong Kong Special Administrative Region Government, the Hong Kong Monetary Authority, and the Securities and Futures Commissions. His expertise is recognized globally, and he has been invited by the Royal Swedish Academy of Science to nominate candidates for the Nobel Prize in Economic Science since 2016. So let us invite Professor Lin to share his wisdom.
Okay, thanks a lot for the invitations. So I got about 30 PPTs. I will make sure that I'm on time. I'm a finance professor, so please, forgive any of my ignorance of the legal institutions. So I want to talk about the new global payment networks and, more importantly, the regulatory oversight. So this PPT was just showing this. This only represent my own opinions, not the institutions, agency that I'm affiliated with. So at the beginning, so I will start from one of the biggest public blockchain, the Ethereum. From this PPT, you can see there are more than 1.7 million tokens contracts on Ethereum, and the top three ones are Tether, BNB, and USDC. And Tether and the USDC, these two are the major stable coins at this moment. Adding together, they account for more than 95% market share of the stable coin. Now, a lot of you might be wondering that why all of a sudden this year people are all talking about stable coin. In fact, this actually comes from a technological breakthrough from this, the ETH, the Ethereum platform. So you can see, starting from this, the EIP 4844, this is a technical upgrade. Since there, you can see the transactional cost has been dramatically reduced. So at this moment, the ETH has more than 200, we call layer 2, public blockchains, and adding together, the ETH has this a key parameter is called TPS, transaction per second, is more than 100,000 transactions per second. So this is a very big numbers, and this actually enable the public blockchain to to take care of this global payment network because of the high frequency. So at this moment, you can see that from this graph, you can see very clearly that the daily transaction, the layer 2s already outperform the base layer, the Ethereum base layer, by a large margin. Okay. So all in all, I just want to say that the reason that we see a surge in this stablecoin is because of technological breakthrough and improvement. So this year, you can see if you look at the crypto trading volume is up and down, but if you look at the stablecoin transaction volume, it goes up very steadily. We know that in July 18 this year, there's a very important law. It's called the first ever stablecoin law that got passed in the United States, and this one is called the Genius Act. Why we call it Genius Act? Because this is called, guiding as establishing national innovation for U.S. stablecoins, a very Trump name. But more importantly, it highlights three things. The first thing is called financial stabilities, to make sure that all the stablecoin issuance are backed by high-quality asset. The second one is called the cross-border parity. In particular, the foreign issuers are subject to the U.S. Regulation for preventing money laundering, terrorist financing, and sanction violations. The third one is the regulatory clarity. This is basically will enable more digital assets to be issued in the future. Okay. So I will not go through these details, but I will just highlight a few keywords: the transparency, the redemptions, and the reserve auditing. These are all very, very important for financial stability issues. And then if you look at the size is actually quite amazing. The underlying assets is about 280 billion US dollars. The USDT and USDC are the two dominant players in this market. If you look at the transactional volume, over the past months, the last month, the total transaction volume is 6.6 trillion US dollar. So this is very I would say magnificent numbers. 6.6 trillion US dollar per month. You might say a lot of them are because of this high frequency trading. If you take them out, still the payment volume amounts to 1.4 trillion US dollar. So, and more importantly, if you look at the same number 5 years ago, you basically see that start from scratch. It's almost nothing. Okay. If you look at the major public blockchain, this stablecoin being deployed, you will see this, the Ethereums, the Tron, and the BSC. They are the major public blockchains. And around the world, there are about 316 million active addresses that are using this stablecoin payment. So adding together, you can see the stablecoin payments is getting pretty close to the total number of ACH, the automatic clearinghouse used by this US banking system. So you might be wondering why this is getting so popular. One of the major reasons is because this is very efficient. So if you look at this is the typical payment method for B2B, B2P, usually takes about 1.5 to 2%, and it takes about 2 to 10 days to do a cross-border transaction payment using a system called SWIFT. I assume everybody knows about SWIFT. The issue of SWIFT is because it engaged multiple intermediaries, lack of standardization, manual processing, lack of transparency, and high cost, so on and so forth. But what about you're using a stable coin? It's peer-to-peer payments using the public blockchain, and the cost, I can show you the cost is as low as 1 cent US dollar, and the time takes less than 1 second. So if you compare these two numbers to the SWIFT number I just talking about, apparently technologically speaking, this is much more superior than the traditional payment method. That's why it's getting more popular. So ironically, on September 29th, the SWIFT announced that it's going to add the blockchain-based ledger to its infrastructures. Okay, so more importantly, if you look at this number, on the left-hand side, you can see this is the global payment currency shares, in August 2025, and you can see Chinese yuan accounts for 2.93%. US dollar is 46.94%. But if you look at the right-hand side, is the payment on the public blockchain using stablecoin. On that, you can see the US dollar-based stablecoin counts for 99.8%. So apparently, US has every incentive to move the traditional payment on chain. So that's the US dollar will be at this moment will be the dominant payment currency. A lot of people talk about this the so-called the treasury holding is actually not a very big deal at this moment. Adding together, they hold about 150 billion. When you compare to the 3.36 trillion US dollar, US treasuries, this is nothing. Okay. So if you want to take a look at the growth of this DeFi, including a stablecoin payment, you will see that developing countries like Latin American, Africa, and Eastern Europe has the highest growth rate. And if you open up this Eastern Europe a little bit, you will find Russia and Ukraine has the highest growth rate. So in other words, when the traditional financial systems is malfunctions, the blockchain-based one can be a good substitute for that. And in fact, in many parts of the world, if you want to buy this stable coin, you need to pay a premium. Like in Argentina, you have to pay a 30% premium. In Nigeria, you have to pay a 22% premium. Okay? And a lot of these countries are the Belt and Road countries that we're talking about. The dominant players in Tether makes a lot of money out of that. I don't have time to talk about their business model. They earned about 30 billion profit in the last year. Now, I want to say one more thing which is quite important in your mind, is that according to the Genius Act, there's a very clear timeline, like 18 months after the enactment date or 120 days after the primary federal payment stablecoin regulators issue any final regulators, and this will come into act. And more importantly, if you are not permitted payment stablecoin issuers, you have a 3-year transition period. But more importantly is that you have to comply with 2 things. The first thing is that the underlying asset must be the high quality safe assets, such as US currency deposits, deposit in Federal Reserve systems, the Treasury security, and so on and so forth. And the second one is that you have to comply with the so-called BSA, the Bank Secrecy Act. So these are the specific requirements. For example, you have to maintain an effective anti-money laundering AML program. You have to keep appropriate records. You have to monitor and report any suspicious transactions. And more importantly, you have to be technically capable to block, freeze, and reject any specific transactions that's required by the US government. You have to keep effective customer identification programs. And the final one, as I just mentioned, is sanction compliance. This requirement is not only for US issuers, but also for the foreign issuers. You have to fully comply with the US order to seize, freeze, burn, or prevent transfer of payment stablecoins. If you look at the largest stablecoin issuer, Tether, we know that Tether is not a legal stablecoin at this moment. It's not a fully compliant. But even with that, you can see Tether frees 700 million USDT in this 112 wallets associated with something, the Iran-linked funds this July. So you can see even Tether's, basically comply with the US sanctions on this. And Tether has its own report. It has frozen over 2.9 billion in USDT tied to illicit activity to date, and assists more than 275 law enforcement agencies across 59 jurisdictions. More importantly, for the 5,000 blocked wallets, 2,800, which means almost 60%, are in coordination with US agencies. So this is the biggest concern. You can think about on the stablecoin payment, which is at this moment 6.6 trillion US dollar transaction volume on a monthly base. 99.8% is US dollar base, and then the major stablecoin issuer will fully comply with the US sanctions or US agencies' investigation. So even in US, people have this kind of a query. They say, look, is this really a stable coin? Which is, we talk about peer-to-peer transfer, permissionless, trustless, all these kind of things. Or maybe this is actually a CBDC by US government. So no wonder that the US government said we no longer need any CBDC here. Because they already has a good substitute, which is the US dollar-backed stable coin. So I know the time is limited. So all in all, I just want to present you all this evidence for your thoughts and considerations that now, because the blockchain-based payment system, technologically speaking, is so much superior to the traditional SWIFT-based. If you want to transfer $1 million from Hong Kong to Nigeria, it only takes you 1 second to do so. But at this moment, 99.8% is US dollar backs, and also the major players, USDT, which means the Tether and Circle, are fully compliant with the US regulatory agencies' sanctions. So this actually raises another question: is do we need another payment method, blockchain-based or other type, CBDC or stablecoin, or otherwise this so-called decentralized financial system is actually getting more and more centralized. It's very centralized right now at the stablecoin space. So this is just my 2 cents. Thanks for listening.
Thank you, Professor Lin, for your very clear and structured overview of the stablecoin and also the global financial governance. So our next distinguished speaker is Professor Wu Xiu-Dan, Associate Professor, Law School, Central University of Finance and Economics. Professor Wu is an Associate Professor of International Law in Law School of China Central University of Finance and Economics after obtaining a PhD degree from University of Milan, Italy in 2011, and postdoctoral research at Law Institute China Academy of Social Science in 2013. Her major research area is international law in new technological frontiers. She has been working on this area for more than 2 decades. Professor Wu is the author of many articles about topical issues in outer space order, internet and data governance, and AI regulation, both in Chinese and English, in peer-reviewed academic journals. Moreover, she has been an expert consultant of China's outer space legislation work for years and provided legal consultation services to governmental and non-governmental entities in China. Join me in welcoming Professor Wu to share her insights on international regulations of artificial intelligence, competition, and cooperation. Over to you, Professor Wu.
Distinguished Mr. Zhang, Mr. Lan, distinguished guests, good afternoon.
To talk about this topic, the international regulation of artificial intelligence through computation and cooperation. AI technology is moving forward with racing speed, while law is lagged behind, especially at the international level. International regulation of human activities in certain fields is usually achieved through computation and cooperation. But nowadays, the AI regulation, it is the computation overriding cooperation, especially through the 2 examples of AI technology. One is autonomous weapon system, the other is the civilian use of AI. So the increased autonomy of weapons through the introduction of artificial intelligence is fundamentally changing armed conflict all over the world. An autonomous weapon system raised profound questions from a legal perspective. As the Austrian foreign minister stated, this is the Oppenheimer moment of our generation. The UN framework discussion on autonomous weapon system can be traced back to 2010. That was a long time ago, but after 10 years, more than 10 years, no substantial international limits on AI weapon has been established. Although there are so many actors within and without the UN framework has involved in this discussion, no matter it is the contracting party of the Convention on Certain Conventional Weapons or General Assembly of the UN, and also the UN Human Rights Council, and also all those states and non-state actors, eco scholars and scientists on AI,
and so many non-state actors and think tanks, they were involved, but no international substantial limits has been introduced. But there is some common understanding. The first thing is they have divergent position as to almost every aspect of AI weapons. One is prohibition or regulation. Prohibition is more based on the arsenic concerns and the human dignity concerns. But regulation believes in the potential for AI to decrease the faculty of the conflict and think this is still immature or unfeasible to regulate AI weapons. Another thing is that the current international law, can they apply or not? And there are different positions as in optimism and pessimism, and they have very different opinions about AI's cognitive and reasoning capacity and in judgment. Some of them saying that the AI is lack of human judgment, and if they are left to make a decision of killing people, that is unnatural and that is violated international law in its nature. Another thing is how to regulate treaty or soft law. Smaller countries and NGOs, they believe in treaty law. However, the big powers, especially the United States, they believe in the soft law regulation method. Although not much substantial result, but there is some common understanding. The first thing is that as the General Assembly resolution indicated, regulation is necessary, and the current international law should apply for the regulation of AI weapons. But this also leads to the discussion into a much more difficult area, as to drawing a line between illegal and illegal AI weapons, there is a need to define AI more accurately. So it is not about what the technology is capable of, but how to control it, how human can control AI uses. There are different definition methods. As in, foregoing example is human in the loop weapons, human on the loop weapons, and human after the loop weapons. It is very simple categorization, but this doesn't simplify the definitional issue. What is in, on, and out, and how to define human control to make the AI weapon systems to decrease the possibility of malfunction and errors. That is very difficult because the AI weapons, they operate in a very uncertain environment, and they are facing a lot of hostile interference and unexpected changes in environment. So human control, it is much more complicated than before. Another thing, if the current international law is applicable, the next step is how to apply them, how to amend and adjust, adapt these current principles. For example, the principle of distinction, the principle of proportionality, to decrease better protect the civilian and component, and how to prevent and avoid impunity. So it is much more complicated than what AI is capable of. Another thing, it is about the civilian use of AI. Also facing the problem of the choices, the binary choices between regulation or not. Actually, in the United States, EU and AI, they will compete in every aspect of AI regulation. For what kind of aims and purposes to promote or to regulate, to promote for innovation or minimize its negative impact. And all kinds of rules can be used to regulate. Ethnical rules, standards, and legislation. Also, they believe in different methods for this regulation. As for the ethnic rules, actually there is more than 300 sets of ethnic rules. And if we look at the the region distribution, we could see that Western European and North American, they make a contribution of about 1/3 of this document. And China is only responsible for 5% of all those documents. First glance look at all these documents seems that they're believing quite similar principles. For example, it is safety, transparency, accountability, privacy. But a closer look at of this concept means they are more different than similar. As we all know, that ethnic rules have a very bad reputation when it comes to achieving global consensus. In different countries, especially in North and South countries, Western and Eastern countries, they have very different understanding as what is these principles, especially if it is about human rights protection, the rule of law, and the responsibility of commercial corporations. Another thing it is about the legislation. 10 years ago, there is only one law on AI, but till the end of last year, we have more than 200. And the EU AI Act could lead even more legislation act. But even so, there were some states believing the non-legislative method. For example, the United States saying it is not a very good idea to regulate, and they believe in the soft law regulation method, believe in self-regulation and the guiding principles. And China is trying to do both. We have policies, we have regulatory documents, but also we are thinking about the idea of to have an AI law. So the whole situation seems that there is a very low level of regulation cooperation. There is no one organization, either it is non-governmental or governmental, has been the focal point in promoting governance cooperation. And also the topics are very fragmented and overlapped, even within the United Nations framework. And also the regulation cooperation is geopolitical and ideological oriented. And the dialogue usually happens in small clubs, and there is no general and holistic mechanism targeted at gathering the global common understanding. The last thing in the low level of regulation cooperation is the low level of participation and lack of inclusiveness and equity. Actually, within the UN framework, only G7 countries participated in all the AI working mechanisms and initiatives. As for the big number of developing countries, usually they are absent or they maintain as a minimal level of participation. So there is a very big risk of marginalization, not only about the technology advancement, but also about the regulation. So naturally, the problem is how to manage interplay of cooperation and the competition. So far, there is only one treaty on AI, and it is within the Council of Europe. And at the global level, the treaty negotiation is not very promising. But actually, the states, they have the common interest in promoting regulation cooperation. They are up to the same things, for example, safeguarding sovereignty and national security. And they want to minimize the public negative impact of AI technology. So the thing is that how to cooperate among the big shaping forces, how the United States, EU, and China, they can cooperate together and they can realize that cooperation and there should be the coexistence of cooperation and competition. They believe in different things and they have different priorities when it comes to AI regulation, but still they need to find a way to cooperate. Another thing is that AI, like internet, it has the regulation involved diversified actors, And there should be a dynamic governance model between private and public collaborations. Another thing is about how to bridge the AI gap through sustainable and equitable development, how to maintain a democratic and inclusive governance. China's Global AI Governance Initiative and EU's Global Digital Compact, they believe in the same things. But the thing is how to implement them, how to put China's very good ideas and concept for regulation into implementation through rules drafting and regime design. So this is what I would like to say about how to promote, how to achieve international regulation for AI technology, to make it more beneficial for the whole global society, and not only for the big powers. They have the technology, but how to make it is sharing the well-being of the AI technology. I believe in China's potential. I believe in China can make a constructive contribution to this regulation. But China is a very newcomer of international legal order. So the big challenge is about the implementation, how to put the good political willingness into good rules and regimes. So that is all from me. Thank you.
Thank you, Professor Wu. Thank you. Yeah. I can see the audience has a couple of questions. So now moving on is to the Q&A sessions. So if you have any more questions or you have any comments, please do share with us. So perhaps I come to a question on AI first, since Professor Wu you just mentioned. It's very timely and relevant. There's a question from the audience saying that given the rapid changes in digital technology, including AI, do you see private international law shifting more to a flexible soft law?
But this is a very interesting topic, as in the dynamic or the relations between treaty and the soft law. Soft law has its merit. The treaty also has its merit. So the thing is that they should not be separate from each other, but they also need to cooperate. So the treaty should lay down the basic principles for regulations, like a framework convention. But also soft law, they are easy to adapt to the to the fast development, so they can make more contribution in the detailed context scenarios for regulation. So that is my understanding. But I believe you have some understanding about the treaty law and the soft law, Professor. Yeah, the private international law.
So, well, my understanding about hard law and soft law is that in the transnational law area, especially when it comes to the material law regulation of technology, hard law instruments are very difficult to achieve because they require a very high level of political consensus that is very difficult to achieve in a short period of time, which is the time the technology mutates very quickly, and therefore achieving political consensus requires a lot of time. Sorry, it was the opposite of what I was saying. And that time is just not something that you can adjust to the pace of evolution of the reality. So by the time you reach enough consensus by governments to come up with a regulation, the technology has mutated already. So it's like you are chasing a train and you are on a horse. We all know from the Western movies that horses catch the trains, but the truth is nowadays the horses can't even see a train passing by. So the hard law instruments in that area might be desirable, but are difficult, and we shouldn't lose hope, but it's a difficult one to do.
Thank you, Professor Durado. So perhaps I go back to Professor Lin. Hong Kong obviously is an international financial center. In terms of IPOs, we are now basically ranked world #1. So back to stable coins, obviously is something, a novel concept and for something new. With respect to the stable coins and global financial governance, so perhaps I would like to ask you about, so what exactly are the key risks and opportunities that stable coins present for the global financial governance, especially in the context of international law?
I know very little about international law, but I try to say more from the finance perspective. Now, first of all, I would say that the payment is the foundation of all financial activities. Okay, so if you think about, for example, in China, there are two gigantic companies. One is called Tencent, the other one called Alibaba. Both of them, they grow up because of their payment infrastructures. So this is the foundation. Now, building on this payments infrastructure, you can have trading, you can have lending, you can have insurance, all other financial activities will be built on that. So I would say, when we talk about the new generation of payment infrastructure, stablecoin, fortunately or unfortunately, we see that U.S. become the dominant player again in this space. So in other words, in terms of international governance, we know that we talk a lot about this long-arm jurisdiction by U.S. or other in the Swiss systems, but we have to realize that the dominance is actually become even more in the crypto space, in the blockchain space, I would say. So on this regard, because the U.S. has made it very clear that the future of their financial system is to move all the financial assets on chain, including fixed income securities, including stocks, including precious metals like gold. So you can see that they're basically we're talking about creating another parallel universe, financial universe on chain. So so I have to say this will be the quite critical moment for the future of finance. In my humble opinion, if Hong Kong want to maintain its role as the international financial hub, we have to do something in this space. We know that Hong Kong has already has a stablecoin law enacted, but at this moment we haven't seen any who is the first batch of issuers, and the time is very critical because if you look at the curve I just showed you, the size, the volume of the stablecoin payment actually doubles just within this years. So the velocities, the speed is quite important. And based on this, the U.S. Treasury's their own projections, within 3 years, the total amount of underlying asset will be around $2 trillion, which is about 7 times of the current number. So with only 2,800 $280 billion, the transaction volume is already getting very close to the transaction of the whole banking system in the US. If you have $2 trillion underlying assets, I would say maybe that becomes the new or the dominant weight in terms of payment. So this is why I think this is a historical moment for Hong Kong. If we want to maintain the international financial hub in the future, we got to do something in this space.
Okay, thank you, Professor. I think our time is up, but one final question probably to Professor Tirado. Since Professor Lin didn't too much cover about the international perspective, so perhaps from your side, we see the potential opportunities. But what challenges do you see that does this pose for harmonizing across jurisdiction from this area?
Sorry, didn't understand the first part. What challenges are posed by what? Sorry.
No, I mean talk about the stablecoin. So from an international rule-making adopting this rapid evolution of digital economies, so what do you see about the challenges across all the jurisdictions?
Well, thank you. As I said, is the velocity of the changing of the subject matter to be regulated that is the main problem. Let me differentiate clearly here 2 spheres. One is the material law regulation from a private law standpoint, and a different one is the regulatory side. And the regulatory side is something which each country must make sure that they provide adequately. And the more consensual it is between the countries, the more likely it is that the trade will be international, because there is a level playing field. So there is a lot of cooperation and coordination between governments in that regard, and doesn't sound like an easy one, but I think it should be tried. It's worth it.
Okay. So thank you once again to our distinguished panel. So perhaps I hereby close this session by expressing my heartfelt gratitude to all the distinguished speakers. Thank you.
Thank you very much to everyone on stage. That was truly an insightful discussion. And can I please invite everyone to please take your seats with gratitude. Thank you. Thank you once again. With the conclusion of our second panel discussion, now it is time to wrap up the event. May we now please invite the Honorable Mr. Paul Lambton Kwok, GBS, SC, JP, Secretary for Justice of the Government of the Hong Kong Special Administrative Region, to come on stage to deliver his closing remarks. Mr. Lam, please.
Deputy Commissioner Zhang Changwei, Your Excellencies, distinguished guests, ladies and gentlemen, may I first express my sincere gratitude to the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR for co-organizing the legal forum with the Department of Justice for the third year since the launch of the event back in 2023. I would also like to thank our moderators and speakers, some of whom have traveled from afar to share their invaluable insights, as well as to all of you for participating in the legal forum this afternoon. This forum has built on the success of the past forum, which stressed on international cooperation and echoed the notion of global governance initiative put forward by President Xi Jinping. One of the core concepts under the GGI is to maintain and enhance multilateralism. China is a staunch supporter of multilateralism and has made consistent contribution to the advancement of international rule of law. In this regard, we had the honor of opening this afternoon forum with Professor Huang Jin's keynote speech on China's contribution to international rule of law. Following the general overview by Professor Huang in his keynote speech, Session 1 looked more specifically at some examples of practicing multilateralism and upholding the international rule of law. We had the benefit of learning from the experts from international organizations and from China on how private international law, international mediation, and the Greater Bay Area can contribute to practicing multilateralism and come up with answers to different global issues in order to uphold international rule of law. In this connection, Hong Kong as a global super connector and value adder, we strongly support upholding the international rule of law under multilateralism. As you may know, the headquarters of the International Organization of Mediation, IOMAC, in Hong Kong opened officially on the 20th of October. The IOMAC is the world's first intergovernmental international legal organization dedicated to resolving international disputes through mediation, and provide an important mechanism for upholding the principle of the Charter of the United Nations. As stated by Mr. Wang Yi, the Minister of Foreign Affairs during the signing ceremony of IOMAC Convention held in Hong Kong on the 30th of May this year, the IOMAC is an actualization of the purposes and principle of the UN Charter. It filled an institutional gap in international mediation and served as an important public good in the field of the rule of law for better global governance. Apart from the Regional Office for Asia and Pacific of HCCH, which has established in Hong Kong, which has been established in Hong Kong by the Hague Conference on Private International Law since 2012. Other international intergovernmental organizations, such as the Bank for International Settlement, International Monetary Fund, the International Bank for Reconstruction and Development, and International Finance Corporation, have set up offices in Hong Kong. Together with the soon-to-be-established office by the Asian Infrastructure Investment Bank, these establishments will further support the city's strategic position as a center for international legal and dispute resolution. And their presence in Hong Kong is also evidence of our championing multilateralism. Alongside the physical setup of institutions akin to building our hardware, Hong Kong also takes in hand capacity building to invest in our software. The Hong Kong International Legal Talents Training Academy, launched in last year's Hong Kong Legal Week, has been organizing practical legal courses, seminars, and international exchange programs, both locally and abroad, to promote international legal talent exchanges. With the expert committee for the Academy, consisting of 3 advisory boards, comprising 17 legal experts and scholars from renowned international, mainland, and local legal organizations and universities, and quite a few of them are speakers at this forum, the Academy breeds and boosts legal expertise, contributing to the country's vision in upholding the international rule of law under the multilateral paradigm. Turning to our section 2, we look further down to the promotion and development of international law through emerging technologies. We had the benefit of hearing from prominent legal experts and technology experts from international organizations and universities their insights on various emerging issues of the interface between the law and technology, ranging from digitalization, cryptocurrency, to artificial intelligence. As technology could be a double-edged sword, bring out convenience and advancement to our daily life on the one hand, but causing some unforeseeable risks to the future of humankind on the other hand, there's a need for the international community to come together to develop international rules that harness the benefit of emerging technologies while addressing the potential risks. My department, the Department of Justice, attached great importance to the development in the areas of law tech and AI. We have established the consultation group on law tech development in January this year to research and formulate specific recommendations to promote the use of law tech. We also believe that forums and exhibitions could provide an important platform for fostering exchanges and cooperation. As part of this year's Hong Kong Legal Week, we will hold the inaugural Hong Kong Law Tech Fest 2025, which will take place from tomorrow until this Friday. The event will bring together legal practitioners, technology providers, experts, academics, and policymakers to explore the fast-evolving intersection of law and artificial intelligence, and to showcase the latest innovative products and services shaping legal practices. Other than exhibition, presenting innovative law tech and AI products and services, there will be expert-led sessions on the practical application of AI and law tech in legal practice, finishing on the last day with a main stage law tech conference under the theme, the AI era, shaping the legal landscape in the 21st century. And you are invited to join the Law Tech Fest either in person here at the Hong Kong Convention and Exhibition Center or virtually online. We have also supported the UNCITRAL Asia Pacific Judicial Summit, which took place yesterday and concluded earlier this morning, which centered around the theme of digitalization and the judicial handling of disputes involving the use of AI. And tomorrow morning, we'll also have the XCCX Symposium to look at the operation of certain Hague Convention in the digital age. And you are also most welcome to join the symposium. Other than the events that I've just mentioned, my department also contributes to the shaping of international rules and meets emerging technologies by participating in various initiatives in collaboration with international organizations and other institutions. For instance, the Department of Justice Project Office for Collaboration with UNCITRAL, established in November 2020 in the Hong Kong Legal Hub, provides support to the initiative of Inclusive Global Legal Innovative Platform on Online Dispute Resolution, or in short, the ICLIP on ODR, to identify possible future work on or in respect of online dispute resolution. Experts meet regularly to explore the possibility of developing harmonized standards to ensure the legitimacy of online dispute resolution processes. UNCITRAL, in its 58th Commission session this year, endorsed the continued collaboration between UNCITRAL and the ICLIP on ADR. This is an example of proactively developing international rules with foresight instead of responding after problems arise in the spirit of the principle of solidarity, which call for choices and actions to be guided by the interests of the international community as a whole. In our rather ambitious attempt to navigate in one afternoon through the macro topics of multilateralism and emerging technologies insofar as they relate to development of international law, I hope you have enjoyed experts' insight and discussion at today's legal forum. And as with most dialogues generally, we cannot realistically aim at resolving all the complex issues at one time, but rather start the conversation and plant some seeds for thought on our minds. As we continue with our yearly exchange through this forum, I'm confident that this incremental, collective, and cumulative efforts will no doubt bear fruit as we look back someday in future. So thank you very much again for joining us today, and I look forward to seeing you at the forum next year and perhaps at the remaining events in our legal week. Thank you very much.
Thank you, Mr. Lam, for the closing remarks. And can I please invite you to take your seat? Thank you once again. Distinguished guests, ladies and gentlemen, the third Legal Forum on Interconnectivity and Development has come to an end. On behalf of the co-organizers, we would like to express our most sincere gratitude to all of our speakers, as well as all of our moderators for their insights and excellent presentations. We also extend our special thank you to every guest who participated with us today, both in person and online. Now, before you leave for today, please do scan the QR code that is on the screen to complete the feedback form, where I highly encourage everyone to participate, as your feedback is very important to us. For in-person participants who require continuing professional development CPD credits from the Law Society of Hong Kong, or advanced legal education ALE credits from the Hong Kong Bar Association, please present your QR code outside the conference hall to register your departure, and also that is to confirm your attendance record. Now everyone, please return your headsets at the service counter before leaving, or you can simply leave it at your table. Thank you again for joining us in person and online. We also look forward to seeing you at other events at the Hong Kong Legal Week 2025. Again, my name is MC Melody Kwan. I look forward to seeing you all again. 再一次感谢各位在现场跟线上的参与，我们期望在香港法律周2025的其他活動跟大家再見。再一次感謝咁多位咧，就喺現場同埋喺線上參與，非常之期待咧喺香港法律周2025嘅其他活動同埋大家再見嘅，再次感謝。